Flamur Shala Focus Strategy, Monday, 17th January 2022. International Criminal Tribunal for the former Yugoslavia. I will read this time a press release, communiqué de presse. It's also from The Hague, 7 May 1997, Tadic case, the verdict. Charges in 11 counts declared inapplicable, accused not guilty on 9 counts of murder, accused guilty on 11 counts of persecution and beatings. Today, 1 year to the day after the beginning of the trial of the accused Duško Tadic, trial chamber 2, bracket or in brackets, composed of Judge Gabriele Kirk MacDonald, presiding Judge Ninian Stephen, and Judge Lal Chand Fora, has handed down its opinion and judgment. Out of 31 counts, the accused has been found not guilty on 20 counts, 9 murder counts because of insufficient evidence, and 11 counts declared inapplicable, and guilty on 11 counts, persecution and beatings, As pointed out by the chamber itself, the judgment is the first determination of individual guilt or innocence in connection with serious violations of international humanitarian law by an international tribunal. The international military tribunals at Nuremberg and Tokyo were multinational in nature, representing only part of the world community. More broadly, and in particular for the victims of the armed conflict in the Prijedor area, the verdict represents the first ever judicial condemnation of the ethnic cleansing policy. Prijedor. So if it makes sense to look on a map when you hear the names of those places. The first ever judicial condemnation of the, again, more broadly and in particular for the victims of the armed conflict in the Prijedor area, the verdict represents the first ever judicial condemnation of the ethnic cleansing policy. So it was the first ever judicial condemnation of the ethnic cleansing policy. So it's not the historical first ever ethnic cleansing, but the first ever judicial condemnation of the ethnic cleansing policy. It is the result of a thorough and meticulous consideration of a voluminous quantity of testimonial and written evidence. During the 6-month-long trial of the accused, 125 witnesses were called and 473 exhibits were tendered by the prosecution and the defense. It also reflects a detailed exploration of legal issues raised for the first time before a trial chamber of the International Tribunal. The written opinion and judgment is a sizable document amounting to 301 pages, with one separate and dissenting opinion of 19 pages and further 30 pages or so of annexes, the indictment, a map of Bosnia and Herzegovina, photos of the model of Umarska camp, photos of Kera Term and Trnopolje camps, photos of a hangar, of an inscription on a wall, and of the model of the White House at Umarska camp. Close bracket. This press release can by no means be a summary of an opinion and judgment which has been carefully worded and which covers a variety of issues. Bracket. Historical background, evidentiary issues, applicable law. Close bracket. And other than the judgment itself, this press release is merely intended as a reader's guide of the verdict. The verdict reads as follows. The accused is a citizen of the former Yugoslavia, of Serb ethnic descent, and a resident of the Republic of Bosnia and Herzegovina at the time of the alleged crimes. The accused was charged with 31 individual counts of persecution, murder, beatings, and other offences alleged to have been committed in 1992 in the Prijedor district, bracket, northwestern part of the Republic of Bosnia and Herzegovina, close bracket, and more specifically at the Umarska, Kera Term and Trnopolje camps in Kozarac, and in the area of ICTY and ICTY. In all cases, the accused was charged with individual criminal responsibility. The accused pled not guilty and raised the defense of alibi, saying that he was elsewhere when each of those acts, brackets, referred to in the counts, close bracket, brackets, is said to have occurred. The chamber finds, 1 or first, by a majority, the presiding judge dissenting, that the accusation of grave breaches of the 1949 Geneva Conventions were not applicable, and that the accused is not guilty on the 11 relevant counts, being, in brackets, being 5, 8, 9, 12, 15, 18, 21, 24, 27, 29, 32, close bracket, running throughout all the charges in the indictment. Geneva Conventions. Two or second, unanimously that the accused is not guilty on 11 counts. Brackets 6, 7, 19, 20, 25, 26, 28, 30, 31, and in part 33 and 34. Close brackets. Charging him with 13 murders, 5 beatings, 2 inhuman acts, and 1 case of abuse of prisoners. The prosecutor has failed either to establish beyond reasonable doubt that the elements of the offences, or to present conclusive evidence linking the accused to the related acts or to satisfy the judges beyond reasonable doubt that victims named were murdered. 3 or third, unanimously that the accused is guilty on 11 counts, bracket 1, 10, 11, 13, 14, 16, 17, 22, 23, and in part 33 and 34, close bracket, charging him with persecution and 14 beatings. The chamber has found the accused untruthful as to his whereabouts at the time of the alleged offences, and has been satisfied beyond reasonable doubt by the prosecution's evidence that the accused either was present at the scene of or did participate into the alleged offences. Then 2. Factual and legal findings count by count. 11 counts inapplicable. As previously stated, 11 counts charging grave breaches of the Geneva Convention of 1949 have been declared inapplicable by a majority of judges. These counts are counts 5, 8, 9, 12, 15, 18, 21, 24, 27, 29, and 32. For further details, see page 8 of this press release. Count 1. Persecution. Accused guilty of persecution. 1. As to the events alleged to have taken place during and subsequent to the attack on Kozarats and its outlying villages, the trial chamber is satisfied beyond reasonable doubt that the accused then participated in the attack on Kozarats and the surroundings areas in the collection and forced transfer of civilians to the detention camp. Then participated in the calling out of 4 Muslim men from a column of civilians and the beatings, calling out separation and forced transfer of non-Serb civilians. Then participated in the beating of a Muslim policeman in Kozarats. Then kicked 1 Muslim prisoner and beat another while they were held at the Prijedor military barracks. Then and killed 2 Muslim policemen in Kozarats. 2 or second. As the events alleged to have taken place at the Omarska and Keraterm camps, the trial chamber has found that the accused then took part in the beating of Edin Mirkalje and Senad Muslimovic in the administration building and the hangar building respectively, in brackets Omarska camp. Then took part in the beatings of the prisoners and took part in 1 mass beating of prisoners from room 2, in brackets Keraterm. 3 or third. 3 or third. As the events alleged to have taken place in the Trnopolje camp, the trial chamber notes that most of the allegations were supported only by the testimony of Dragan Opacic, whom testimony under the pseudonym of witness L was later withdrawn. The only remaining portion of initial charge deals with alleged incidents of transfer and unlawful confinement in the Trnopolje camp. The trial chamber finds beyond reasonable doubt that the accused participated in the transfer to and in the initial confinement of non-Serbs in camps generally, and in the Ternopolia camp in particular. However, the trial chamber finds that the accused did not take an active role in the continued confinement of non-Serbs in the Ternopolia camp. 4. As to the alleged participation of the accused in the seizure, selection and transportation of individuals for detention, the trial chamber is satisfied beyond reasonable doubt that the accused participated and was aware that the majority of surviving prisoners would be deported from Bosnia and Herzegovina. 5. As to the allegations of plunder and destruction of personal and real property of non-Serbs, the trial chamber states that evidence regarding the accused's role in the destruction, plunder and looting is non-existent. 6. The acts of the accused constitute persecution. The trial chamber notes the horrendous treatment inflicted of the non-Serb population of Opština Prijedor on the basis of religion and politics. A policy to terrorize the non-Serb civilian population of Opština Prijedor on discriminatory grounds is evident, and that its implementation was widespread and systematic throughout. At a minimum, Opština Prijedor is apparent. The event described in paragraph 4 of the indictment, in brackets, count 1, closed, occurred with this context of discrimination. With regard to the accused, the trial chamber notes that he was one of the first SDS member in Opština Prijedor, and in his own estimation a trusted SDS member who was asked to run a crucial plebiscite in the Kozarac area. As organizer of the plebiscite in Kozarac and president of the local SDS, the accused had knowledge and supported the plan for a greater Serbia. He himself admits this knowledge and support for the plan when he describes himself as an enthusiastic supporter of the creation of Republika Srpska. The trial chamber concludes the accused's role in inter alia, the attack on Kozarac and the surrounding areas, as well as the seizure, collection, segregation and forced transfer of civilians to camps, calling out of civilians, beatings and killings described above, clearly constituted an infringement of the victims' enjoyment of their fundamental rights, and these acts were taken against non-Serbs on the basis of religious and political discrimination. Further, these acts occurred during an armed conflict, were taken against civilians as part of a widespread or systematic attack on the civilian population in furtherance of a policy to commit these acts, and the accused had knowledge of the wider context in which his acts occurred. Again, so SDS is this Srpska was the Srpska Demokratska Stranka. It's a Serb Democratic Party. It continues then with the accused is thus guilty for a crime against humanity.